Asset titling is very important in estate planning, especially when you've created a revocable living trust. If the assets aren't titled properly, then you're going to get into a situation where a probate is required. A probate would be required if a person dies and that deceased person still owns assets in their name. So asset titling removes that problem while you're living, transferring everything into your revocable trust so that the trust owns all of your assets at death. If the trust owns all of your assets at death, there's no need for a probate, and therefore you've saved your family thousands of dollars because they don't have to worry about going to court to get a will probated. Now, depending on the asset, most assets, generally speaking, should be titled immediately into the name of the trust. The first asset that I'll discuss is your bank account. It's always best to have the bank account titled in the name of the trust, because if you become incapacitated during your lifetime, then your successor trustee can use the funds of the trust to pay your bills and expenses. Now, when titling a bank account in the trust, some banks will tell you that you cannot do that and that you have to open a new account. So some people may not want to go through the headache of updating deposits and payments which run through a particular account. So in order to avoid that, they can fill out a pay on death or transfer on death form that the bank has and designate their trust as a beneficiary. So that way, if the person dies, the proceeds of that account would transfer automatically into the trust and therefore avoid probate. Real estate also needs to be titled in your trust. If it's not, then you could be faced with a probate if you forget to transfer your home, your vacation home, or any other type of real estate into your trust. Oftentimes I'll get people asking me, what is the difference between joint tenancy and tenancy in common? The primary difference is with joint tenancy, when one joint tenant dies, that interest of the joint tenant automatically transfers to the other joint tenant without any probate that's required. It transfers by operation of law. Joint tenancy with right of survivorship is a common method of real estate ownership when you may be dealing with unrelated parties. For example, if you have a couple in Arizona who isn't legally married, but they want to purchase a home together, then typically they'll take title as joint tenants with right of survivorship. So if one of those joint tenants dies, the interest automatically passes to the surviving joint tenant without any type of probate that's required. Now, there may be scenarios where the parties don't want that result. They want their interest in that real estate to go to whoever their beneficiaries or their heirs are. So in that scenario, they would want to own that real estate as tenants in common. If it's owned as tenants in common, then that interest in that real estate can be devised however they want to when they die. So the difference between joint tenancy with right of survivorship and tenancy in common is, with the joint tenancy, it's going to, the interest in whatever asset will transfer automatically to the other remaining joint tenants without any sort of probate or transfer that needs to be effectuated at death. It happens automatically. With the tenancy in common, that tenant in common interest can be transferred according to the deceased tenant in common's will or trust. Real estate, if it's not titled properly, can go through probate when the real estate owner dies. So if the real estate owner has created a trust, then that interest in the real estate needs to be transferred to the trust either while they're still living, or there needs to be what's called a beneficiary deed. A beneficiary deed is a type of deed that Arizona allows to be recorded on real property, which provides that when the owner of that property dies, a beneficiary listed in that deed would inherit that property without a probate. So a beneficiary deed is a way to avoid probate in Arizona for real property, and it is a effective means to transfer it at death and avoid probate. When you open a bank account, there's one thing you can do to provide who inherits that account when you die. A bank will have a form you can complete called a pay on death or a transfer on death designation form. That form, when completed, allows you to designate a beneficiary to inherit that account when you die automatically. There's no probate that would occur. All the person would do, or the beneficiary would do, is walk into the bank, show them a copy of the death certificate, and then the bank will transfer ownership of the funds to that beneficiary. If you created a revocable living trust, you could designate the trust as the beneficiary on that form. Now, if the value of that account is more than $75,000 at the time of your death, and you hadn't completed a beneficiary designation form, then that account will need to go through probate. However, if the value is less than $75,000, then Arizona allows you to complete what's called a personal property affidavit. That's a form that the account owner can complete and submit to the bank, which would allow the bank then to transfer the value of that account to the beneficiary after death without having to go through probate. However, that only works when the value of all accounts are less than $75,000. Any questions about asset titling? I'm happy to answer those questions for you. For a free consultation, you can give me a call at my direct number, and happy to get you on the calendar.